Señor Gil Pereg, señor Gil Pereg, escúcheme por favor lo que le voy a decir. Estamos por iniciar el juicio en su contra. Para permanecer en la sala de debates, usted debe permanecer en silencio y respetuosamente. Si usted no hace silencio, lo voy a tener que sacar de la sala, señor Gil Pereg. En ese caso, usted va a ser custodiado en una celda cercana al tribunal, desde la cual va a poder seguir todo el juicio, va a poder ver y oír todo lo que ocurra en la sala, y en caso de que usted desee en algún momento intervenir, se lo hace saber al personal que lo custodia y va a ser traído nuevamente a la sala. Pero si usted insiste con esta actitud, lo voy a tener que desalojar de la sala. Por favor, ¿está listo el jurado, señora secretaria? Que ingrese el jurado. Todos de pie para recibir al jurado.
Todos de pie, ingresa el honorable jurado.
Please take your seats.
Habiendo prestado juramento el día de ayer, el jurado se declara formalmente abierto el debate en estos autos número 4145/19, seguidos a instancia fiscal y de la querella particular contra el señor Gil Pereg. Señor Gil Pereg, ¿es ese su nombre correcto? Su DNI, señor Gil Pereg, es 94.618.393. Bien. Señor Gil Pereg, antes del ingreso del jurado, yo le advertí que si usted quería permanecer en la sala, debía hacerlo en silencio, con respeto y con decoro. De lo contrario, usted va a tener que ser trasladado a una sala contigua al tribunal, desde la cual va a poder ver y oír todo lo que ocurra en la sala, y en caso de que usted desee participar, se lo hace saber a las personas que lo custodian. Pero no puede continuar gritando en la sala de debate. Bien, bueno, señor Gil Pereg, basta. Por favor, trasládenlo y que permanezca en la sala escuchando todo lo que ocurre aquí en la sala. ¿Cómo no? Sí, no hay ningún problema. Bien. Bueno, mientras esperamos que verifique la Oficina de Información Pública la señal, les doy la bienvenida. Les agradezco mucho a todos los jurados, porque el personal de la oficina por jurados me hizo saber que todos arribaron con suma puntualidad, que a las 8:30 ya estaban todos aquí en el edificio del Polo, así es que les agradezco mucho su puntualidad. ¿Cómo están? ¿Han podido descansar anoche? ¿Pudieron dormir bien? Bueno, respetaron la consigna que les di ayer de no comentar el caso con nadie, de no hacer referencia a este caso ni en grupos de WhatsApp, ni con amigos, ni siquiera con sus familiares más cercanos deben discutir este caso. Yo ya se los expliqué ayer, pero se los voy a recordar todos los días cuando terminemos la jornada de debate para que ustedes lo tengan presente. Bien, no sé si de la Oficina de Información Pública ya está todo listo, Martín. Bien, bien. Le hago saber a los defensores que en caso de que el señor Pereg en algún momento del juicio, que va a estar viendo y escuchando desde su lugar de alojamiento, quiere intervenir, ustedes nos lo hagan saber, doctores. Serán ustedes los responsables de comunicarnos si el imputado en algún momento desea declarar y volver a la sala, en tanto lo haga en silencio. Estamos esperando que se logre la conexión y ya empezamos.
Okay, so we are ready.
Bueno, entonces, como yo ya algo les adelanté el día de ayer, la jornada de hoy está pensada para que yo les dé a ustedes las instrucciones iniciales. Después, las partes van a hacer sus alegatos de apertura, va a comenzar el Ministerio Público, es decir, los fiscales, luego la querella y luego la defensa. Después de esos alegatos de apertura, vamos a hacer un breve cuarto intermedio para que ustedes puedan ir al baño, tomar agua, lo que deseen, y reingresamos a la sala a ya empezar a recibir los testimonios. Hoy vamos a comenzar con los testigos de la Fiscalía. Ustedes van a escuchar a los testigos del Ministerio Público. Vamos a tratar de terminar las jornadas lo más temprano posible para dejarles tiempo a ustedes para que estén con sus familias, se hagan cargo de sus responsabilidades, puedan descansar. Esa es la idea. Al mediodía vamos a tener un cuarto intermedio de aproximadamente 1 hora para que ustedes puedan almorzar. Bueno, entonces,
having said this, I will give you the initial instructions. This is the admonition for you to know what will go on during these proceedings. So, you took an oath to be the jury in this trial. Here, Mr. Pereg has been accused of taking part in facts that have been defined by the district's attorneys as a homicide with enhancements against Piria Sarusi and a simple homicide against Lili Pereg. The defense states that the defendant is not the author of these crimes because he is unpunishable due to his mental condition. The definition and the legal elements of these crimes will be explained to you at the end of the proceedings. By the end of these proceedings, you will have the responsibility of deciding whether this accusation has been proved beyond all reasonable doubt by either of the parties. So, instruction number 1, the duty of the judge and the jury. I am the judge, and my duty is to chair these proceedings and to guide it according to the law. I need to exercise all the police powers and law enforcement powers that correspond to me. This means that the parties need to behave in accordance with my resolutions and orders. In addition to this, after hearing the evidence and after each of the parties present their closing statements, it is my responsibility to explain to you which are the legal rules that apply. This means which is the law that you need to observe and to apply to take your decision in this case. You, the jury of the people, are the ones who are going to try these facts. And this means that you have the responsibility to decide which elements have been proven beyond all reasonable doubt. And for this, you only need to consider the evidence that will be submitted during this trial. As jurors, you are the ones who have the exclusive responsibility to decide about the value presented, the value of the evidence presented and submitted by each of the parties. And then you will apply the law that I will explain to you by the end of these proceedings. Finally, I want to tell you that you are the only ones who will decide whether the defendant is guilty or not guilty, and you will do this through your verdict. So, the duties of the judge and the duties of the jury are different and are well defined and do not overlap. In addition to having the judge and the jury here, we have the public prosecution, the private prosecution, and the defense. So in this case, the accusation is made in this case by Mr. Fernando Uso, the district attorney, and Claudia Rios. They are the ones who are going to publicly accuse the defendant, and then the private prosecution in charge of Claudia Velez, who represents the son of one of the victims, Mr. Guy Sarusi, who is putting forward this private accusation. In this case, the defendant is Mr. Gil Pereg. I can refer to him using the words indicted or defendant. We have the counsels of the defense, Maximiliano Legrand, Sebastián Garro, and Lautaro Lacheta. They are the ones that are going to defend Mr. Pereg. Whenever I speak about the parties, I will be referring either to the district's attorney, to the prosecution, or to the defense. If at any time during the trial there is disagreement or objections rise between the parties, and I resolve in favor or against one of them, you should not interpret that I am favoring one of them. I will base my decisions on the law. Both you and I need to be completely unbiased and impartial. Now, instruction number 2 about the development of these proceedings. Before continuing, you need to understand how these proceedings work. At the beginning, the first attorney will speak, followed by the prosecution and then by the defense, and each of them will tell you their version of the facts. These are known as the opening statements. These arguments or statements and everything said by the attorneys during these opening statements are not evidence, and you should not regard them as evidence. After this stage, we will see and receive the evidence, first from the office of the public prosecutor, then from the prosecution, and finally from the defense. We will have experts here who will speak under oath and will be examined and cross-examined by the parties. Here you will be able to see pictures, objects, and other pieces of evidence that have been admitted. After this, first the district attorney, then the prosecution, and finally the defense will have the possibility to make their closing statements. These arguments, once more, are not evidence. After that, I will explain to you how the law applies to this case, and with that information, you will start your discussions. You should not create a final opinion about the case until hearing everything that you will hear here, everything said by each of the parties, and the instructions that I will provide you about the law. It is paramount for you to understand that until then, this means until you go into your discussion, you should not discuss this case between you. Instruction number 3. We have some prohibitions that apply to the jury. The case has to be tried by yourselves based only on the evidence submitted to you during the trial. You should not conduct research on your own. This means that you cannot read the newspaper, you cannot watch TV or news programs about this case, you cannot use a computer or your cell phones to go into the internet to find information about this case. In addition to this, you cannot talk to people with knowledge about these topics, such as lawyers, psychiatrists, or other professionals about this case, and you should not try to find videos or pictures of the places where the facts occurred. And this is valid for you as long as you are here in this court and as long as you are home during these proceedings. And this is an absolute prohibition. Jurors should not hold conversations of any type with family members or friends about the places and the people involved in this case. Not even your closest relatives should make comments to you or ask questions about this case. Remember that you cannot get in touch with the parties, with either of them, neither the public prosecutor, the prosecution, or the defense outside the hearing room until you have pronounced your verdict. If any of you needs to tell me something, then you can do this in writing in a signed document through the guards. Don't read messages and don't accept messages related to this case or to your duty as a juror. Don't talk or discuss this case among you, and don't ask for advice from anyone else for any reason. Doing so would be a breach to your obligation of being impartial, and this can lead to sanctions and penalties. Instruction number 4. Taking notes and making questions. You cannot make questions to the witnesses, to the experts, or to the parties. Should any of you have difficulty to hear what's being said by any of the experts or the witnesses, then you can raise your hand to tell me. You can make notes during this trial, and for that you will be given some paper and a pen. But please remember that your notes should not distract you from what's going on here in the room. Your notes are just an aide-memoire, just to help you remember. They are not evidence. Number 3, you should not be influenced by the notes taken by another member of the jury. Number 4, your notes don't replace the recording that is being made of this trial. If during your discussion you want, you can watch the recordings of specific statements made by the witnesses. Remember that these notes are confidential. During the breaks, these notes will be left inside the room. By the end of these proceedings, the secretary will take all these papers and all these notes, and they will be distracted. Number 5, constitutional principles of this process. It is very important for me to mention some of the rules that are part of our legal system and our constitution. With this, I mean specific guarantees and rights that the defendant has in this trial and that any other person would have if in the same situation. First of all, we have the presumption of innocence. Our Constitution states that every person is innocent until proven differently.
The person who is accused in trial has no duty of proving their innocence. The defendant is not obliged or forced to prove anything, despite the fact that he could decide to do so, since he is presumed to be innocent as stated in our Constitution. He has the right not to declare. In every process, in every legal process, the defendant has the right to not to declare or to declare at any instance during trial. Neither silence nor the moment where he decides to declare have to be understood as a signal of guilt. Therefore, if Mr. Pereg would choose not to declare, you cannot take this attitude as proof against him, as evidence against him, and this shouldn't influence your verdict in any way. Evidence? Well, the burden of the evidence of proof, the attorneys are the ones who have to assess the proof and evidence beyond any reasonable doubt. If they were to fail in this task, you need to declare not guilty to the defendant. The defendant doesn't have the right to prove his innocence, although he doesn't have the duty to declare his innocence, although he has the right to do it. He has the right to present proof in favor of him, evidence in favor of him. There is reasonable doubt, and as a defendant has the right to innocence in case of reasonable doubt pertaining to the existence of the fact and on the punishment or conviction of the defendant. In that case, you have to determine a verdict of not guilty. Reasonable doubt does not mean forced doubt or imaginary doubt. This does not mean that this doubt is based on pity or on mercy or on prejudice. This doubt is based on reason, on evidence, and on common sense. This is the evidence that logically stems from all the evidence or from the lack of evidence during trial. It's not enough for you to believe that the defendant is possibly guilty. If that were to be the case, you need to find the defendant not guilty, since the prosecutors have not convinced you about the guilt of the defendant beyond any reasonable doubt. You also need to remember, however, that it is almost impossible to prove a fact with 100% certainty. The accusation does not need to do so. So, in conclusion, if you are fully convinced of the guilt of the defendant beyond every reasonable doubt, it's your duty to find the defendant guilty. Otherwise, if there is reasonable doubt regarding the guilt of the defendant, your verdict must be not guilty. I will broaden these explanations in detail in the final instructions when we finish trial. Instruction number 6, regarding the evidence. As members of the jury, you will have to decide which facts have been proven. For this, you need to evaluate the evidence that is shown during trial. Just as I stated previously, you shall not consider evidence and you shall not base your decision on what the different parties show in their opening statements that you will listen to briefly at the beginning of this trial. Also, you cannot base your verdict on what I myself or the attorneys say during the trial. During the trial, it's possible that the attorneys formulate objections. What the different attorneys say when they formulate these objections is not taken as evidence. You shouldn't consider the fact that I declare procedent or improcedent the different objections, or that you're excluded from this very room to resolve these matters. The notes that you take during the trial are not evidence. Anything that you have seen or that you have heard outside of this courtroom does not constitute as evidence. You need to decide upon this case only based on the evidence that was shown during trial. Evidence could be the declarations of the experts, material documents, material objects that will constitute as material evidence. The credibility of those people attesting and testifying during the trial and the importance that each testimony has is a responsibility of the jury. So you will decide whether you believe everything that a witness is saying, if you partially believe on what a witness is saying, or if you just don't believe in what a witness is saying. Deciding upon the credibility of a witness, you must decide the whole testimony, and you could consider, among others, the following factors. First, the opportunity and capacity that this witness had in order to hear, perceive, listen, or see, or to acknowledge the matters upon which he or she is declaring or testifying. The quality or the memory that this witness has regarding what he or she is attesting to. Also, the attitude of the witness while they are testifying. Also, if the witness has any prejudice, bias in their testimony, and how reasonable the testimony of this witness is when they testify these related to the rest of the evidence that was shown during trial. 6. If you have any relationship with the defendant or with the victim. 7. If the witness shows any contradictions that are impossible to explain further his testimony. It is important for you to understand that the evidence does not depend on the number of witnesses that declare upon the same fact. If there is one witness that proves to be credible, that could be enough to prove a fact. This means that you cannot decide upon this case just by counting the number of witnesses of the different parties, but also attesting to the evidence and proof of each testimony. As I've already explained, the defendant is not obliged to declare, but if he wishes to do so, you must know that, different from the witness, the defendant is not declaring under oath. So he could say false or true things without these implying the commission of felony. Number 7, freedom of choice of the jury. You must know that the jury is independent, sovereign, and responsible for their own decision and verdict. You need to act and feel free of any interference or pressure from the judge, from the government, from the different parties, or from any other party or person because of their decisions. Neither of you, members of the jury, could ever be subjected to penalties considering the verdicts that you come up with, unless you decided this against your consciousness or by corruption or by bribe. Having concluded with these instructions, general instructions, the DA can start with their opening statements. Thank you very much.
Good morning, ladies and gentlemen. Today you are the jury of the facts. We will begin today by analyzing this case, which is a terrible murder. This cruel murder was committed, as we will show you, by Mr. Pereg. This homicide, this ruthless homicide, implies for the defendant that he will have to be held responsible for this homicide with an enhancement that has to do with the offender's relationship to the victim, his mother, and at the same time he used a fire gun against his aunt. One of them was strangled, the other one was shot. This, as I said, was a ruthless homicide. Faced with this situation, we will tell you how we came to this situation, and I will tell you something about the strategy of the defense as well. First of all, as I said yesterday, Argentine law presumes that all of us are legally capable unless proven differently. There's no magic formula for us to hold this discussion when it comes to a person being punishable or unpunishable. This is something that we will try to prove, and that actually we will prove, though the defense will try to prove the contrary. But this is like a movie. This is not just about a single picture. So for us to know what really happened that fatidic day, we need to know what Pereg was doing before, during, and after these events, because this will show us that there is a timeline that shows consistency in terms of his mental capabilities. This day that the crimes were committed, he shot it with a firearm. He shot at his aunt and strangled his mother. This was on January 12, 2019, in the middle of the day. At that time, this occurred, and now we need to prove that there was a malicious intent. We're fully certain of this. And also, there was desecration of these bodies. And we need to analyze why this was conducted in such a cruel way, and at the same time he concealed the crime. So what happened in the middle? Let's see what he was doing before this homicide. He owned companies, he engaged in banking transactions, he owned and carried guns, and he had approved or gone through the tests that are necessary for him to buy these guns, but then he committed this crime. Let's see what happened afterwards. After that, he visited the apartment that had been previously rented by the mother and the aunt. He made a he presented a false report to the police regarding the whereabouts of these women, and also he had reported previously that the guns were stolen before from him, and he would not appear to be concerned. But then he said, I found these guns. And he said that he had found the gun that he previously reported to be missed. Then he started to speak with the media, showing a full legal capacity, appearing normal before the cameras, and then he transferred arms to the defense lawyers. So today, when we think that he is admitted to a mental hospital, they will tell you that this was voluntary, but this is not true. The mental hospital known as El Sauce and also the mental hospital Pereira didn't want to admit him at the same time, but the defense will tell you that this is voluntary and that if he were to go to prison, he would kill himself. At the same time, he continues to make decisions about his assets, about his properties, even though they will show that, or they will try to show you that he is insane. He continues to make these decisions. And whenever he comes to the hearings, when we don't have the presence of the media, he is not meowing like you saw today. Then he's able to speak and he says, I don't want to go back to the mental hospital. He speaks about the type of food that he wants to eat. He speaks about the type of pavilion that he would like. So he speaks and expresses his will and what he wants like anyone else would do. So I need to tell you this in advance before you hear what the defense is going to say. The facts here are that these two women are dead, that they were killed and murdered by Gilad Pereg with his weapons, and that they were buried in his premises. So the author was Gilad Pereg. In the third place, and here we need to pay special attention, the defense will say that he cannot be punished, that he is unfit to plea, and they will tell you that he suffers from hallucinations and deliriums. But this is so absurd that even he himself knows that this is absurd. When we went to buy or to purchase a gun, he would not meow. He would say, I want this weapon. He made a bank transfer, a wire transfer, and then he went home. He was not walking like a cat when he went outside the street. You will hear them speak about lycanthropy, but then you will hear that he said, I decided to be a cat. I decided that I didn't want to be a man. And this word, decided, speaks about decision, about a will, about capacity. Of course, he has an unusual personality, but having an unusual personality, and here we should mention that it's hard to know whether there's something such as normal or usual, this doesn't mean that he cannot be held responsible for his acts. So you will hear all these theories about his mental capacity. But here what criminal law wants to know is whether he had critical judgment, whether he was able to guide his actions, whether he can tell right from wrong. He needs to be able to understand what his acts are. And we know that he's able to understand because he was fully capable of going to the police, of talking to the police, of buying or purchasing guns. He's able to follow the law when he wants to. So this is what I told you yesterday as well. Please don't let yourselves be deceived. And here I'm using the word in Spanish, engatusar, and I chose this word because it shares the same root than the Spanish word for cat. But these words means trying to persuade something, trying to sweet talk somebody into believing what we want. And he will try to have you believe that he didn't know what was going on. He will try to sweet talk you into believing that he is innocent and that he is unfit to plead. But this is not true. He should be held he should be held responsible for his criminal acts. Finally, you were able to see him. You heard the meowing. You saw him. So once again, I will ask a favor from you. When you decide your verdict, which the evidence actually shows that needs to be a verdict of guilty, when we think about the justice that we need to make today, if he meows, then you should bark even louder. Bark because the law is on your side, because you need to implement common sense for him to stop and to end with this shameful deceit. Now, Mrs. Rios will very briefly explain what happened that day and which is the type of evidence that we will hear now, because now we need to stop talking and to start proving all these events.
Thank you. Good morning. Dear members of the jury, my name is Claudia Rios. I'm the prosecutor. And what is the main function of the DA attorney ministry? Our function is to investigate when there is a felony, when there is a crime, and who are the responsible members or the responsible person of these felonies, of these crimes. The DA has a social interest, that is to act objectively, unbiased, a social interest of two women that are no longer with us. We have nothing against Mr. Gil Pereg. We just move forward with the personal interest of these two people that can no longer speak because their life was taken away from them. And it was the defendant, Mr. Gil Pereg, who took their lives. Today, you have a great responsibility, the responsibility of doing justice. I would like to ask you to take down notes, to observe, to listen, because at the moment of deliberation, you will have to put together all the evidence that you will be faced with. This fact happened on January 12th between 10 and 12 a.m. when Mr. Gil Pereg took Period Sarusi and Lily Pereg, his aunt, by bus to his own house on Roca 679 in Guaymallén. Prior to that, he went to look for them at an apartment that they had rented a day before that, on January 11th, on España Street. And when he was in his own house, there is actually a construction work. In that very area is where he killed them. He shot Lily Pereg 3 times in her thorax, killing her in her chest. And he strangled his mom. However, after they had died, both of them, he put an iron in their vagina and in their anus, and also an iron in their skull. Then he buried them 1 meter underground. But after having buried them, he put stones, gravel, and dirt so that nobody could find the corpses here. Focusing on the evidence, first of all, I would like to tell you that when he kills his aunt, this firearm that he had used belonged to him. But this was the firearm that he had previously reported as being robbed. You're going to see all these evidence before you. There are witnesses, they're going to be passing on their statements, and they're going to tell you how Mr. Gil Pereg developed in society, the scientific police officers that will tell you what they found in the different raids that they did and in the apartment raids that the victims had rented. The firearms that were found, the people from ballistics, and the technical reports that were done. Also, you will hear the statements of the technological crime officers that will explain you how each security camera from different places took images of the victims and of the defendants. Also, we will have a specialist in genetics that will tell us what are the reports and analysis that he carried out, and also the forensics that performed the necropsia and actually will tell you what were the lesions and the wounds that the victims had and what was the cause of death. All these is evidence, and the fact has been enhanced by this DA as a homicide, enhanced by the use of firearms, aggravating by the use of firearms in Lily Pereg's case, and also an enhanced murder due to kinship because he killed his mother. The task that you will have at the end of the day today, at the end of the trial, is to deliberate and to discuss. So put all the evidence together, take down notes, observe, listen, because at that very moment you will have to trust yourselves. You will have to trust on what you will be carrying out. I would like to ask you that at that time you declared the unanimous guilt of these men, because only by a unanimous guilt verdict you will make justice. Justice for Lily Pereg and justice for Piria Sarusi. Thank you very much. Now, the prosecutor will be doing her statement. My name is Claudia Velez. I'm a member of the public agency. We call ourselves prosecutors, and we assist and represent the rights of the victims and of their family members. In this very case, as the judge stated, I'm representing Mr. Guy Sarusi and also his siblings that are sons, daughters, and nephews of the victims that we are going to see during this trial. I'm going to be working with the DA to show you that on January 12th, 2019, Mr. Gil Pereg killed his mother, Piria, and his aunt, Lily, in a complete state of awareness. He knew what he was doing, and that is what he wanted to do. I believe that now, at the beginning of the trial, it's important for you to know these two ladies. These were two ladies that were victims of this crime. They were working women, they were family women, and they were loving women. Piria Sarusi was the mother of the defendant, Gilad Pereg, and she was also the mother of my representative, of my client. She, in Israel, worked as a public official. She was part of the police force, and she had served as a police officer, and she worked for the fiscal authorities of Israel. She was a hardworking woman. She loved her work. However, she planned to retire because her first grandchild was to be born, the son of Pereg Sarusi, another of her daughters. She never got to do this because Piria came to Argentina to visit Gilad, and the following day, after arriving to Mendoza, Gilad killed her. Also, she was a mother. She was a caregiver. She was a loving mother, very much involved in the life of her sons and daughters, and she helped all of them. She even helped Pereg. He had been living for many years in Argentina, and however, she was always sending him money and being worried about him. She considered herself responsible for her children and responsible for their lives. And that is what Vered, one of her daughters, stated. She said that her mom was a loving mother and that her house was a house that they would always love going to. Even some of her children still lived with her. Lily Pereg was the youngest sister of Piria. She was 54 at the time of death, and she came to Mendoza visiting her nephew together with Piria. Lily was a very studious woman. She was a speaker at many conferences. She was an academist, and she had studied in many prestigious universities in Europe. She had different PhDs in Sydney and PhDs in Germany. She was a member of the University of New England in Australia for 18 years, and during this last time, she was working as a professor, as a college professor in Australia. Lily was married to John. She didn't have any children, but her nephews were like her children, like children of her own. Despite of the distance where she lived, she was also always very, very present as a member of her family. So much so that when she traveled, that is when she wanted to celebrate different occasions, and everybody loved her truly. There was a homage paid at the time of her death at the university where she used to work at the University of New England in Australia, where the whole academic community of faculty, colleagues, and students ended up very shocked and very moved by her loss. She was not only a hardworking woman, but also she was very much present to all her students. And this is an attribute that is very much valued in all the universities of the United States and Europe. These are the two women that ended up dead, and these were the two women that were victims of the ruthless murder that Gil Pereg perpetrated. As I mentioned before, I'm going to be working with the other DAs in showing you that Gil Pereg, completely aware and conscious in his mental faculties and knowing what he did, killed them. As the DAs mentioned before, once he killed them, he perpetrated several maneuvers in their corpses, and not only this, he also reported them missing, totally intentionally trying to deviate the investigation of this case so that he wouldn't be signaled out as the responsible of this case. During the development and during the hearings in this trial, you will listen to witnesses, you will see the evidence, and at the end of the trial, you will deliberate. You will analyze and study and discuss all this evidence before you. As the DAs stated, I'm very sure that there's only one conclusion possible for you to reach, the conclusion that Gil Pereg killed them knowing what he was doing, killed them with criminal intent, and that is why I'm very sure that unanimously all of you will reach the verdict that Gil Pereg is the responsible author of murder enhanced by kinship and murder enhanced by the use of firearm for Lily Pereg and Pierre Sarusi. Thank you very much.
Thank you very much, Mrs. Velez. And now we will give the floor to the defense for their opening remarks. Ladies and gentlemen of the jury, good morning. When with my colleagues from the defense we analyzed how to approach these opening statements, first of all, we realized that there was a technical difficulty, so as to say. We found ourselves to be in a disadvantageous position because we are allowed just one speech against two, one from the district attorney and one from the prosecution. We raised our objection yesterday and we decided to split our arguments in two. So first of all, I will explain to you which is the important role that you play as a jury, and then I will give the floor to my colleague, Mr. Legrand, who will tell you more about our position and what we believe. After hearing the district's attorney, after hearing Mr. Russo and Mrs. Rios, it seems that the only possible option here is for you to find him guilty. You are being asked to give a conviction here, as if there was nothing else here for us to discuss or analyze, and the truth is that this case could be solved in a different way. And this is what you need to discuss. You should not accept the previous statements thinking that there is no further discussion allowable. When you think about conviction in a prison in our province, and then the other option is to take Mr. Pereg to a mental hospital. So you have two options here. And these options are very different. Of course, we are not saying that Gil Pereg should be released or acquitted. Whichever your decision, in no case, and I want to insist on this, will Mr. Pereg be allowed to walk freely outside the streets of our province. So the options here are to confine him or to have him confined in prison or in a mental hospital. And here we again have two types of situations. Inside prison, he can still have the mental health law applied, or otherwise he can go to another country, and it would be better for him probably to go to Israel. This will be the case if you believe on the defense. Otherwise, if you do what the prosecution is asking you to do, he will go to prison in Mendoza and we all will have to pay for that. They are saying that the only chance that you have is to unanimously decide to take Mr. Pereg to prison. When I was listening to them, I thought that they almost wanted you not to think. They wouldn't allow you to have your own opinions and your own beliefs. So whenever you analyze a piece of evidence today, whenever you consider the depositions and the expert reports that you will see, please defend your own beliefs. It is not necessary for you to reach unanimity. If you believe that there is a best solution for this case which is different from what the prosecution said, please try to decide your verdict in that sense. Thank you very much, Lautaro. Good morning, to all the members of the jury, I have to say that it is very hard to do what you will have to do in this case. This is a difficult case. And the main thing that we want from you is for you to do justice. What does it mean to do justice? A long history, after 2,500 years of history, justice has been defined in different ways. But the definition that we like and that we prefer is the one given by Ulpiano, who was a Roman, a legal expert that lived before Christ, that said that each person should receive what he or she deserved. So his definition of justice was to receive what you deserve. So, if the defendant killed somebody in his right mind, he should be punished for that. However, if the defendant perpetrated these acts without being aware of what he was doing, then he should not be found guilty. This is very important because we know that this is a terrible event. We're speaking about a homicide, but here there's a component of humanity. As human beings and as jurors, and this is a very noble and important role that you're playing today in society, you need to behave as humans. So don't act as animals. Here the prosecutor was asking you to bark back at the defendant, and this is not justice. Justice is something about, justice has to do with humans, with human behavior. Justice has to do with responsibility. We have a lot of evidence. You will hear many witnesses, you will hear many experts presenting their reports. So don't just stick to what one witness said, because there's no single piece of evidence capable of leading you into a fair decision. You need to assess all the different pieces of evidence. Once you have seen everything, once you have pondered about these things, only then you can reach a fair decision. Because this looks like a movie, but if you only watch part of it, you will not be able to understand the entire picture, the entire situation. Here you need to watch the entire movie from beginning to end in order to make your decision. So let's listen to all the different witnesses. Let's analyze what happened, because this is the only way in which we will be able to reach the truth. This is the only way in which you will be behaving as fair human beings, and this actually will bring a shift into our society. We will shift towards a more rightful society, because we perceive unfairness in our society every day, because we go out on this run. When we are outside in the streets, we are raped, we are robbed. Why? If we have people like Mr. Buzo here who are in charge of justice, and he's been working in justice for many, many years now, and still we are worse and worse every year. So today you have the opportunity to give each person what he or she deserves, to do justice. We cannot treat a mental health patient as if he were a normal person who can be fit to plead. This is your opportunity to make a better society. It's been said that Pereg had transferred and made transactions with guns, with weapons, that he entered into business transactions before the event. Do you remember this local character from Mendoza known as Loco Juan? This was a very dear character for us all who live in Mendoza. Loco Juan, or Mad Juan, as he was friendly called, He would take the bus, he would buy his food. Sometimes, actually, the police would allow him to act as a traffic officer for a while in a friendly way because he was a very loved character here in the city, of course, under supervision. And he knew how to take the bus, he knew which his stop was. He would take selfies with the people from Mendoza. Everyone knows him, everyone knows his character here. But still, when he committed sexual abuse against a 10-year-old girl, he was found unpunishable and he was taken to the mental hospital El Sauce. So, if I go and purchase a gun, yes, I can embark into transactions, I can purchase things, and this doesn't mean that later on I cannot be declared unpunishable. This is a fallacy. Because actually, and you will hear this being explained by the experts, people who suffer from a mental condition are fully capable of conducting acts of daily living. Actually, we have schizophrenic people who are physicians, who are lawyers, and who are fully capable of engaging into these activities of daily living. So, what we tell you that even though Mr. Pereg was capable of doing complex things and tasks, still he can be found to be unpunishable. Because otherwise we would engage in a fallacy. And this is what you will hear from the experts, from the scientists. I'm sure that each of you has met people who suffer from mental conditions and who still are able to engage in activities of daily living and even to perform some complex tasks. Now I'm going to tell you a brief history about my client, about Gil Pereg. He studied in Israel, and then it was when the first signs of his mental condition were perceived. He would run naked outside campus, and actually he also was living in terrible conditions of hygiene. This was true back then. Today, when you saw him, he was much more cleaner than he usually is because he's right now in the mental hospital El Sauce, and the personnel there has been able to get him to shower and to have a more neat presentation. But this, of course, has to be done by specially trained people. And in this Technion Institute, which is where he studied in Israel, the first signs of his mental condition appeared. As I said before, he would run away naked in the campus. And in Israel, when this started happening, actually he was admitted to different psychiatric hospitals. His mother tried to help him, and she realized at a point that it was not possible for her to help him with these pathologies because it was just too severe. So she sent him to South America because in Israel it was a big problem for her. It is true what was said before. She would send him money. She would send him dollars every month, and this was his only source of income because Gil Pereg had engaged in many businesses. Actually, she would give him advice, she would give him ideas for him to invest, for him to recover. This is what she wanted. But all the businesses he entered into failed because he had a mental incapacity, and everyone actually would take advantage of him because of that. All the different proceedings that he was a part of, the civil proceedings he was a part of, derived from the fact that he was being deceived and that he was the victim of scams. This was true for some of the soccer courts that he built. He invested $60,000 in these, and when these courts, these premises to play football were built, they could not be used because the work was done in such a terrible way that it was impossible for them to be used. It was a scam. And these things happened to them because he was not mentally fit. So his personality and his situation became worse and worse over time.
He arrived here with a specific weight. Actually, he weighed 120 kilograms. He's very tall indeed. And now he has lost a lot of weight. A lot of weight indeed. So much so that, as you can see in the pictures, from the moment of the event, he was a very, very skinny man. So this image that he has nowadays is what the experts call the typical aspect of a psychotic person. A person who is not careful about their hygiene, a person who has a delicate situation regarding their health, and he lived with 37 cats. He called his cats his children, and this is not something that happened after he committed the crime, after the event. Actually, he used to call the cats his children long before the event took place, because this is part of his delirium, of his delusion. He used to sleep in a mattress surrounded by boxes filled with cat feed, actually, and he didn't feel like a human being. He didn't perceive himself as a human being. He has always felt as a cat, as an animal. Why? Well, he didn't consider himself a cat because this is something that he came up with one certain day. At a certain point in life, he got divorced from humanity. He separated himself from humanity because he believed that human beings polluted nature, killed animals, destroyed the planet, that performed wars and crimes, things that he saw in the army. Because when he had his first crisis, he was actually in the Israeli army, and that is when he started becoming detached from humanity and feeling himself as an animal. This is a delusion, and this is why he considered himself to be a cat. But this is not something that happened after the event. This is something that happened long before the event. This is the way in which he lived, and he treated his cats as children. Regarding his pathology, the disease that he has is paraphrenia, and the experts have stated that he has lycanthropy and that he also has delusions. I'm not going to tell you so much about paraphrenia, but these is characterized by hallucinations and delusions, and lycanthropy is a disorder in which the medical community defines it as people perceiving themselves and acting as animals. And delusions have to do with hallucinations and experiences that the defendant actually had and went through. These are technical definitions that are going to be explained by the experts later on, but the important thing is how these impacted on the defendant's lives. And these, of course, had an impact in the fact that he couldn't understand the criminality of his acts. He didn't want to do what he was doing, and if he did what the event states, Dr. Castells, who is one of the most prestigious experts in Argentina, stated that he didn't want to do what he did. Mr. Castex, Dr. Castex, is a doctor of great renown nationally and internationally. He has written many books in psychiatry and psychology. He has been quoted and called upon by the court in many different cases. The Supreme Court of Argentina actually quotes Castex in as one of the main sources in order to solve different trials. He examined Pereg here in Mendoza, and he said this person has delusions, has paraphrenia, and this person is unfit to plead. He's unpunishable. So, what is delusion? I don't want to give you such technical definitions, but I will show you an audio of what a delusion actually is. This is a delusion of Pereg being attacked by someone or something. His speech is very difficult to understand because he seems to be under an absurd delusion, and he's stating that he was attacked by something filthy with a huge mouth that wanted to eat him up. He's stating that something wanted to eat up his head, and that the only thing that he could think about was in killing himself and chopping off his own head. That is a delusion. This is something that disconnects or detaches us from reality, where reality acquires a different meaning, not the one that we see. So these people that have delusions and hallucinations, they see and they hear things that are different from our own reality, and therefore they act upon them. In the case of Pereg, these are his children that are his cats, and he has delusions of different monsters. Certain things that we should consider. Well, it's necessary to understand the opinion of the experts. Please, listen to scientists, listen to experts, and don't let yourselves be deceived and fooled by statements that don't have a scientific basis. Science cures diseases. Science takes us to the moon. Science allows us to have cell phones and computers. It is science that actually works in real life, not. We need to understand what the experts say, and based on that, we need to make a statement and a decision. Thank you very much. Let's not base ourselves in magic, let's base ourselves in science. Thank you, doctor.
So now that each of the parties has finished presenting their opening statements, as I promised you at the beginning, we're going to have a short 15-minute break for you to go to the restroom or drink some water. After that, we will continue. So now it's 10:19. So please be back at 10:35 to continue with the discussions. Please stand up as the jury will leave the room.